Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today as we are continuing our coverage of Massachusetts versus Brian Walsh. We are in day 9 and the state rested yesterday. So we are seeing, we're going to see if the defense is going to put on a case. So let's get right to it. And welcome in, everybody. Appreciate your patience with us. And let's just get straight to it. Okay, here we go.
Please be seated.
You are. In the matter of the Commonwealth versus Brian Walsh, Norfolk Indictment 2023-0091, continuation of jury trial. Counsel is present in court. Counsel, starting with the Commonwealth, kindly identify yourselves for the court and the record.
Good morning, Your Honor. Greg Conner for the Commonwealth.
Good morning.
Good morning, Your Honor. Ann Yass for the Commonwealth.
Good morning, Your Honor. Tracy Cusick for the Commonwealth.
Good morning, Your Honor. Good morning, everyone. Kelly Porges on behalf of Mr. Walsh.
Good morning, Your Honor. Larry Tipton.
Morning. We need the defendant.
Thank you, gentlemen.
Your Honor, for the record, the defendant's present in the courtroom.
Thank you, Madam Clerk.
Thank you. Thank you.
All right. At the close of yesterday's day, the defense raised with me what I have listed as 5 separate issues that it wanted to alert the court to with regard to the expected testimony of Mr. Walsh today. As an initial matter, does the defense still intend to call Mr. Walsh today?
We do not.
You do not? All right. Does that moot every issue that I researched last night?
I apologize, Judge.
No, I just want to make sure that the 5 issues that you raised and the issue with regard to the plea are no longer on the table. All right. I will conduct a colloquy with the defendant then now, and my intention is to defense intend to call any other witnesses.
We are not.
All right, then we'll close tomorrow. We'll do the charge conference immediately after the rest of the day. Let me just put in the record, so the record is complete. The Commonwealth previously, and I ruled on this at the side of the bench previously, the Commonwealth previously asked this court to exclude the defendant's plea of guilty, and I guess the only way that would come in at this point is if he were testifying. But I just want to put in, to the extent that I previously disallowed the defendant to go there with any other witness, and I frankly don't recall if I have previously, I want to put in the reason why I excluded that testimony now. The Commonwealth did file a motion in limine to exclude evidence that the defendant pled guilty to misleading the police into Ana Walsh's disappearance and improper disposal of her body. After consideration, I allowed and still am allowing the Commonwealth's motion for 2 reasons. First, the defendant has failed to show how such evidence is relevant to the remaining charge of murder. And I specifically acknowledge that I read this morning the defense's motion to admit the evidence of his guilty plea, which has been docketed as 216. That was filed on December 11th, 2025, this morning, I believe. I have read it, but it doesn't do anything more than to set forth the elements of the crimes of murder. Based on defense counsel's opening statement, it appeared that the defendant was going to testify in this trial, and at that time, he could have made reference to his plea if I so allowed him to. But whether or not he is charged or pled guilty to such actions relating to his prior plea of guilty before this court is irrelevant to whether he murdered his wife. Second, the inclusion of the evidence of the defendant's guilty plea on the two charges would risk the introduction of extraneous factors as part of the jury's consideration on the murder charge. As explained by the SJC in Commonwealth versus A Juvenile, 396 Mass 108, 112, it's well established that a jury's verdict must be based solely on the evidence in the case without regard to the possible consequences of their decision. And there's a specific instruction in my draft jury instructions that addresses this. Continuing with this case, the role of the jury is to make findings of fact and determine the guilt or innocence of the accused without regard to probable punishment. To inform jurors of a sentencing consequence of their verdicts is to invite a results-oriented verdict and possible deviation from the basic issues of the defendant's guilt or innocence. I also cite to Commonwealth versus Sanchez, 70 Mass Appellate Court, 699-701, 2007. While the defendant here is not seeking to enter evidence of the possible consequences of a guilty verdict on the murder charge, the rationale behind the holding in A Juvenile applies with equal force. If the defense was permitted to tell the jury that he pled guilty to the two lesser charges, there is a risk, substantial risk, that the jurors will consider the defendant's impending punishment on those charges when determining his guilt on the remaining murder charge. Indeed, the defendant has not offered any other rationale for the entrance of such evidence, and as was stated in Commonwealth versus Ferreira, 373 Mass 116, 124, 1977 case, the jury's function is not to weigh possible verdicts with an eye towards dispensing mercy in certain cases or imposing heavier penalties in others. Rather, the jury's function is solely one of fact-finding with respect to the legal standards regarding innocence or guilt. Accordingly, the defendant is not permitted and has not been permitted to put evidence before the jury of his prior guilty pleas in this matter. And Madam Clerk alerted me to also file this morning 321, pause, the Commonwealth supplemental motion eliminate to exclude evidence of the November 2025 guilty plea, which I will concede I did not read because I just got it when I stepped on the bench, but I'm not sure it makes a difference in light of my ruling.
It's moot at this time, Your Honor. Thank you.
All right, is 216 something you filed earlier? Why does it have this number?
No, that's my error, Judge. That's my error. I corrected it on the original. It should be 318. It's my poor vision.
Okay. So just so the record's clear, when I said a moment ago I did review what the defendant filed this morning. It's just not 216, it's 318. All right. On the docket. All right, I see that I have two other pleadings up here, which I will address in brief. One of them I was going to address anyway, in substance, maybe not exactly as it's presented. Those are items number 319 and 320. Let me talk about 319. I haven't read it either. It's a motion to prevent the Commonwealth from basically, I believe, and Attorney Tipton, you can, or Porges, you can illuminate me greater, but you don't want them saying he promised you something in the opening statement that he didn't deliver.
That's right, and after consulting with the Commonwealth this morning, they have no intention, they've told us they have no intention of doing that.
So I have already pulled out some case law on this, and where the boundaries are, and I was going to give it to you in the charge conference anyway to make sure that you were aware where the boundaries are. The SJC has spoken on this issue of what's permissible and what isn't. The Commonwealth is allowed to get into it a little bit. I will alert you to those cases, and that's where I intend to draw the line as to what's permissible. I probably have them on my bench right now, but I couldn't tell you where they are. But when we get to the charge conference, I'll give those to you so you both have the benefit of my research on that issue. The other motion, 320, is I expect the defense will renew after I bring in the jury, ask you if you're going to present any evidence, and you will rest. And I'll hear you at the side of the bench with regard to that. So now, I do want to conduct the colloquy with the defendant at this point.
Would you like them sworn, Your Honor?
Hold on a second, because I'm not sure I have my colloquy with me on the bench, despite the fact that I have quite a few binders here. I think the one I need is in my office, so stay tuned. Nobody move.
Welcome to Zoom Government.
I think so.
Enter your participant ID. Please enter the meeting code.
Madam Clerk.
Thank you, Judge.
Mr. Walsh, if you could stand and raise your right hand, please. Do you solemnly swear or affirm the testimony you shall give in the cause now in hearing to be the truth, and that you shall give all true answers to all questions as put to you by the court in the cause now in hearing? So help you God.
I do.
Thank you.
Excuse me.
You can be seated. I just didn't, was wondering if you were asking me if I wanted him over on the witness stand. I do not. Mr. Walsh, one important decision that all defendants in every criminal trial need to make is whether or not they're going to testify in a particular case. You have an absolute right to testify at this trial, and your right whether or not to testify is solely your decision. This means that you are not required to take your attorney's advice. I'm sure that your attorneys, Attorney Tipton and Attorney Porges, have told you that if you do testify, the Commonwealth has the right to cross-examine you, that is, the right to ask you questions. If you do not testify, and you and your attorney request me to do so, during my final instructions to the jury in the law on this case tomorrow, I will tell the jury that you, like all persons charged with a crime, have the right not to testify, and that the jurors may not speculate about your decision not to testify. First, I'm going to ask you some preliminary questions. Sir, in the last 24 hours, have you had any alcohol or alcoholic beverages?
No, I have not.
In the last 24 hours, have you taken any prescription medicines?
I have not.
In the last 24 hours, have you consumed any legal or illegal substances?
I have not.
Is your mind clear here today?
It is.
Tell me in your own words, what are we discussing?
Whether I'll testify or not in my trial.
Right? Have you discussed with your attorneys the decision about whether or not to testify in this trial?
I have.
And have you had enough time to discuss your decision with your attorneys?
Yes, I have.
Have your attorneys discussed with you the pros and cons of testifying and not testifying?
Yes, they have.
And do you understand what your attorneys explained to you about your right to testify?
Yes.
Has anyone threatened you or promised you anything to get you to give up your right to testify on your own behalf?
No.
Have you made a decision about whether you wish to testify at this trial?
Yes, I have.
And what is your decision?
I will not testify.
Does any party wish me to ask any further questions before I make my findings?
No, Your Honor.
No, Your Honor.
I find that the defendant, Brian Walsh, freely, voluntarily, knowingly, and intelligently has waived his right to testify at this criminal trial, and that he's done so with the knowledge of its consequences. I accept his decision. We can bring the jury in.
All rise. Jurors entering. Hear ye, hear ye, hear ye. All persons have anything to do with the Honorable Diane Fernandez, Justice of the Norfolk Superior Court. For your attention, you may be heard. Courts here at Call of Massachusetts in this honorable court. Please be seated. Please turn off your cell phones.
Morning, jurors. Morning. Jurors, we'll start today with the 4 questions. Jurors, were you able to comply with my order that you not speak to anyone about this case?
Yes.
Were you able to comply with my order that you not do any research about the case?
Yes.
Were you able to comply with my order that you not go on any social media or access any news media?
Yes.
And do you still all have open minds?
Yes.
With those 4 questions all answered in the affirmative, we're ready to begin today's work. Does the defense wish to call any witnesses in this case?
We do not, Judge.
Defense rests?
Defense rests.
All right. I'll see counsel at the side of the bench. continue to have open minds as we finish these last chapters of this trial. Have a great day.
All rise for the court, please. Jurors, close your notebooks and follow me.
Couple of housekeeping things. Yesterday at the side of the bench, we had a discussion about, during Mr. Mootwoo's testimony, in which I asked that a certain document be marked as, I think it was M or N for identification, Madam Clerk. Which was it?
N, I believe. The hammer?
No.
Oh, the other one was N, Your Honor.
N for identification. Has that been done? This is a question to the defense. On cross,
Page 53 of that transcript.
I want that whole document to be marked for identification. Has that been done?
Okay, I'll get that to the court this morning.
And just so the record is clear, as I understand it, that is a multi-page document of which Mr. Mootwoo was asked to review a single page of, but it comprises a record of his police interview. Is that correct?
That's correct, Your Honor.
Okay. Are the parties ready to do the charge conference, recognizing that I haven't given you a draft yet because of the way things played out? I did stay last night and draft the jury instructions with the benefit of two things so far that I considered, or at least three things. One was what I had marked for identification the other day, which is the first 2 pages of the model homicide instructions. I'd asked each of the parties to mark up, so to speak, those 2 pages of the SJC's model instructions. And so you did at my request, and I had the benefit of that information. I also received yesterday, Madam Clerk, if you could get me while I'm talking, the defendant's request for jury instructions concerning consciousness of guilt, emotional evidence, and bad acts. I had that. I considered that as I was drafting the draft instructions yesterday, and I'll talk to you about that. What I didn't do, and I sort of made a mental, because I ran out of steam, frankly, yesterday, I know that very early in the case, before the case started, that the Commonwealth had filed pleadings with regard to jury instructions, and I made a mental note to go back to those this morning, but I didn't, frankly, have a chance to do that since the day is unfolding a little differently than I expected at the end of yesterday. So I tell that to you so that you know that if there's something that you wrote in there that's still relevant now, it might still be, that I don't have that fresh in my mind anyway. All right?
Yes, Your Honor.
So, said more bluntly, if there's something in that I don't go over now that you want to persist with, just...
Your Honor, there is actually, with respect to the consciousness of guilt instruction, potentially. I don't know if it would make sense to take a brief break so that I could collect my notes on that topic.
All right. I will take a brief break before we, and what I'm going to intend is this. The draft instructions as I have them right now includes what I tried to do is, when I was scratching my head, saying to myself, why do they want this instruction in? I put it in anyway, and then I put it in italics, so that should be your clue that I'm questioning either why this is in here. For instance, the object of the killing must be a human being that the defense has asked for. Question mark, why are they asking for that? So the italics either means you asked for it, I'm questioning why you want it, be prepared to answer that question. Or in the instance of the instruction, I have instructions drafted right now and this is in part 2 of the instructions. Impeachment by prior conviction, impeachment by prior inconsistent statement, and impeachment by prior bad act. And in particular, in the prior bad act, I took a swing at attempting to fairly describe the evidence that's been presented to the jury with regard to the defendant's bad acts. I tried to do it neutrally, but there may be other words that you like better. So those are in italics, even though the whole instruction isn't in italics. Who's closing for the defense?
I am.
And who's closing for the Commonwealth? The address of the Refuse Center, 300 Forest Street, Peabody?
Yes, Your Honor.
The defense now seeking the instruction with regard to the defendant's right not to testify.
Yes, Your Honor.
I'll add it. Commonwealth seeking a mode of instruction.
Yes, Your Honor.
Again, look for the highlighted language in the consciousness of guilt instruction and see if there's some other language you would prefer that adequately captures post-trial evidence. All right, let me propose this. I'm going to make those edits and additions based on the information that you just provided, and then I'm going to have Madam Clerk shoot you a copy of the draft instructions. And I know you probably want to be spending your afternoons working on the closing arguments. So I think it would be reasonable, given what I think is relative to other cases, the instructions are pretty straightforward. By that I mean there also was a lot of agreement with regard to your submissions as to what you wanted in these instructions. And so it's sort of the second half of the instructions that the special instructions. I will go back and look at what the Commonwealth submitted early on in the case. Should I presume that everything you wrote then you're still pursuing today? ADA Cusick.
Yes, Your Honor. The Commonwealth was seeking a direct and circumstantial evidence instruction, a consciousness of guilt from the MCLE instructions, and an expert witness instruction.
All of those instructions are presently in the charge, in the draft charge. So thank you, because that prevents me from trying to find out where it is.
Yes, Your Honor. It's under general instructions at the back of the pleading, the preliminary request for jury instructions, and we just provided the name of the instruction from MCLE.
All right. I don't know if I probably grabbed it. I'm not a huge consumer of the MCLE instructions. I usually use other sources, but you can see what I came up with, and you can tell me whether you disagree with it. But we talked about the consciousness of guilt instruction, and it does not, I've never given, as far as I recall, a version that put my thumb on the weight of the evidence. So it presently either says you've heard evidence suggesting, what page is it on? Hold on, it's on page 27. Yeah, it's some evidence suggesting. I don't think to my knowledge or recollection, I've never used anything that was stronger than that. Yes, counsel.
I just wanted to say, I hope you haven't spent any time on this. The object of the killing must be a human being. You mentioned that this morning.
It was just not crossed out of your version, I don't believe.
And it should have been.
It's not an issue.
I know. I said it should have been.
So just take it, can I take it out?
Yes, sir.
Thank you. I didn't spend any time on that. There are other things I spent, like about 5 issues that were of interest to me. But I learned quite a bit researching those, so didn't have a chance to look at those issues recently, and it's always good to remind yourself of them. I'll take that object of the killing out. All right, so let me get these to you, and I'm going to suggest, what's it, 9:30? Does 11 o'clock sound reasonable?
Yes, Your Honor.
Gives you an hour and a half to stew on. I'm going to get them to you in about 10 minutes. I don't have much to change here from what I drafted. 10:30. 10:30?
Yes, sir.
Sounds good.
10:30 it is. If you need 11, you let me know, but we'll say presumptively 10:30.
Your Honor, could the Commonwealth also request the cases the court referenced about the extent the Commonwealth
I'll
can
get you
mention
those.
opening?
I will get you those. There are parameters. I looked at it about 2 or 3 days ago, maybe over the weekend, something like that. Again, something I hadn't looked at in a while, and it's always good to look at the law. But I'll get it to you.
Thank you, Your Honor.
All rise.
All right, so that is very interesting, and we can pop ahead because nothing happened. So I'm going to replay opening statements here. If you guys want to watch Dustin Duran's sentencing, we're dual streaming. So if you want to go join us over there, I'm just going to replay openings. So if you guys want to join us over at the other link, that's cool. Let me just find openings here, because I want to hear what they had to say.
Jurors, I know that you will try this case according to the oath that you took this morning. In that oath, you promised you would well and truly try a just judgment.
Thank you, Your Honor. Your Honor, may it please the court?
It does.
On January 4th, 2023, Teresa Marchese returned to work after New Year's holiday. She works at Tishman Speyer, and she is the Director of Human Capital Management. That is to say that she's the Director of Human Resources. And Tishman Speyer is a real estate management company, but it's a global real estate management company. It has buildings all over the world. And this office that Ms. Marchese works in is in Washington, D.C. When she returned to her office in Washington, D.C. that morning, she was alerted that one of her co-workers' husbands was trying to find her co-worker. The co-worker was Ana Walshe, and her husband is Brian Walsh. Teresa Marchese knew Ana Walshe because she hired her. She hired her in February 2022 to work at the Washington, D.C. office of Tishman Speyer and to manage some of those buildings in Washington, D.C. She also knew that Ana Walshe commuted from Cohasset to Washington to work at Tishman Speyer, and that her husband, Brian, and her 3 children were still in Cohasset at this time. She also knew where Ana Walshe lived in Washington, D.C. Ana Walshe had bought a townhouse right near where Teresa Marchese lives in Washington. So when she heard that Brian Walsh was looking for Ana, she got concerned. And she spoke to her boss, Jeff Chubb. And the two of them went into a conference room and called Brian Walsh. Brian was calm, and he said that on January 1st, Ana left their Cohasset home for a work emergency and had to fly back to Washington, D.C. And he hasn't spoken to her since then. This is the longest they've ever gone without speaking. So, Teresa Marchese went and drove to Ana Walsh's townhouse. She took another employee with her, and on the way there, she had another conversation with Brian Walsh. Brian was calm, and he gave her the combination to the garage so Ms. Marchese could get into the building. Ms. Marchese got there. She was able to look in the windows. Nothing was broken. Nothing was out of order. She got into the garage. And she found some cardboard boxes that had yet to be unpacked, some car seats, no car, no Ana Walshe. Now the door from the garage to the home, that was locked. So she couldn't get inside. So, Ms. Marchese called Mr. Walsh back again. And she told him that she was going to loop into this conversation Tishman Speyer's global head of security, who also works in Washington, D.C. His name is Hugh Dunleavy. He's a retired Secret Service agent. Mr. Walsh is coming. Mr. Dunleavy is looped into this conversation on the phone, and Mr. Walsh's demeanor changes. He becomes very upset. Mr. Dunleavy calms him down, asks him a series of questions, and Mr. Walsh repeats. Ana left the home in Cohasset on January 1st to come to Washington, D.C. for a work emergency. Mr. Dunleavy follows up. Have you called the police? What is the local police department in your town? You live in Cohasset. You need to call the police. The call ends. Mr. Dunleavy works with the Washington police and helps facilitate them getting into the home in Washington, D.C. And Ana is not there. He also calls the Cohasset police just before noon on January 4th. And he reports Ana missing. Hugh Dunleavy from Washington, D.C. calls the Cohasset police, and that is the first time Ana Walsh has been reported missing to the police. And it was done just before noon on January 4th. And no one has seen her since January 1st. Over the next few weeks, it'll be the honor of Ms. Cusick, Ms. Yaz, and myself to represent the Commonwealth. And in that time, we will prove the defendant guilty beyond a reasonable doubt of the premeditated murder of his wife, Ana Walsh. And we're going to do that by presenting evidence to you. And evidence will come to you, as Her Honor pointed out, in two different forms. One is kind of tangible. You'll see photos of the family home in Cohasset at 516 Chief Justice Cushing Highway. You'll see videos from different stores. You'll see Ana Walsh's banking records. You will also see objects, like a Tyvek suit, like a hatchet, like a hacksaw. Now, in addition to those objects, you will hear from witnesses. Witnesses like Teresa Marchese and Hugh Dunleavy, who I just mentioned. You'll also hear from a group of witnesses that are Ana Walsh's friends and colleagues. They will tell you that Ana was 39 years old in January 2003. She was married to the defendant. She had 3 children. They'll tell you that she was a Serbian immigrant, that she came to this country and began working in the hospitality industry by working in hotels in Washington and Massachusetts, and that she transitioned to real estate. She got the opportunity to work for Jem Mutlu, who had his own real estate company. She actually wound up running that company for him. That was until February 2022, where she got what Brian Walsh would refer to as a dream job, where she got to work for Tishman Speyer, and she would make more money than she had ever made before in her career. She had purchased a townhouse in Washington, D.C., and she was expecting to have her family come with her. However, Brian and the children had stayed in Massachusetts. And the reason is that Brian had previously pled guilty to a count of fraud in the Boston Federal District Courthouse. But he hadn't been sentenced yet. Now, he was accused of owing over $400,000 of restitution. At this point in time, Ana was the breadwinner for the family, and she had moved to D.C. She was still commuting back and forth, but looking to have the family join her in D.C. And Brian, too. However, when she bought the townhouse, she did this with the aid of a real estate agent by the name of William Fastow. She was introduced to Mr. Fastow from her former boss, Jem Mutlu. Mr. Fastow will testify, and he will tell you that they became friends, and that friendship became romantic. And that carried on into November of 2022. when Ana needed to go visit her mother, who was sick back in Belgrade, Serbia. Ana flew to Dublin Island the weekend of Thanksgiving, and Mr. Fastow joined her for that weekend. She then flew and visited her sick mother in Serbia, and then would return back to the United States. Mr. Fastow, after Dublin, would go back to Washington, D.C. But Ana missed Thanksgiving with Brian and the children. And then on Christmas Eve that same year, Ana went out to dinner with Mr. Fastow. They went out to dinner in Annapolis with another couple. And she stayed the night. And she was supposed to get a flight out on Christmas Day. But she couldn't get a flight. So she had to drive up from Washington, D.C. to Cohasset. And she missed Christmas Eve and most of Christmas Day with Brian. She would fly back to Washington, D.C. And on December 29th, she would go to dinner with one of her friends, who will testify before you. And that friend will say that she was uncharacteristically tired and emotional. You'll also hear from a series of witnesses that dealt with Ana Walshe right before New Year's. She returned back to Cohasset on December 30th, and she was going to stay with the family until January 3rd. You'll hear how she went to a bar class, B-A-R-R-E. It's an intensive ballet class. You'll hear from the instructor who will say that she did exceedingly well in that class. A person who was with her in a nail salon will testify. She got her nails done on New Year's Eve. And Mr. Mutlu will testify. He went over to the Walsh family residence on New Year's Eve for dinner. 3 adults were there. It was Mr. Mutlu, Brian, and Ana. He got there around 8:30. He brought some snacks for the kids. Actually got to play with the oldest child. And he spent the night talking to his friends. He'd characterize them as jovial. They shared champagne. They weren't drunk. They were enjoying the new year. They actually signed the champagne box. And you'll see that, where they were looking forward to the new year. Brian cooked. Brian was attentive. Brian also said to Mr. Mutlu that night that he had lost his phone, it had been misplaced, but he had felt free as a result of it. Mr. Mutlu left that home on New Year's Day at 1:30 a.m. And there was no mention of a work emergency in Washington, D.C. that would require Ana to fly out or leave the family home at 6 or 7 a.m. that day. Now on January 4th, after Hugh Dunleavy had called the Cohasset Police Department, the Cohasset Police Department dispatched Officer Greg Lawrence to go speak to Mr. Walsh at his home. Officer Lawrence went. He was met outside by Brian Walsh. Brian Walsh informed Officer Lawrence that Ana had left on January 1st, had taken a Uber or Lyft to Logan Airport to fly out to Washington, D.C. for a work emergency. Gave her a phone number for Ana Walsh, described her as 5'2", that she was 39 years old, approximately 115 pounds. He hadn't heard her. Officer Lawrence went back to the Cohasset Police Department. Worked with other Cohasset police officers, trying to find any connection to Uber or Lyft or local taxi cabs. Cohasset police would then begin the process of pinging Ana's phone. You're going to get to see the records from that, but essentially the process involves the cell phone carrier, in this case Verizon, sending a signal out to the phone to try and locate it. And the Verizon records will show that the last time that phone that belonged to Ana Walsh interacted with the network was shortly after 3 a.m. on January 2nd. And when it did so, it was in the area of the Walsh home. That same day, Cohasset Police also tasked Detective Schmidt with investigating this case. He and Officer Lawrence would go back to the Walsh family residence at 516 Chief Justice Cushing Highway and interview Brian Walsh. And he recorded it. You'll get to hear the recording. And Brian will talk about how Ana was commuting back and forth from Cohasset to Washington for work, how there were some issues with his federal case, and how Mr. Mutlu had come over for dinner that night on New Year's Eve, and how Ana had to leave between 6th and 7th on January 1st. He also, in that interview, described what Ana was wearing when she left the home. Blue-gray hunter boots, a black jacket, and an Hermes watch. So Sergeant Smith will testify before you, and he will tell you that he worked on this missing person investigation and called in additional resources to help. On the 5th, he had his own department do a search of the woods near the family home. On the 6th, he called in a task force made of several different police departments to do further searching of the woods in and around the Walsh family home. Contacted the state police to use their resources. He also got the opportunity to speak to Mr. Walsh on January 5th, January 7th, and January 8th. And when he did those interviews, he was accompanied by detectives from the state police. And those interviews were recorded. And you'll get to hear those interviews. And Mr. Walsh, during those interviews, will explain that he and Ana were happily married. He had no knowledge of any extramarital affair. That Ana had her dream job. That it was taking care of the family, and conversely, he didn't take a salary this year out of his company that was a consulting company. He told the police that he owed over $400,000 in restitution on his federal matter, that this case was causing stress on his marriage, that he might have to go to jail. He said that they were very happy, and that the biggest problem was that they were apart. Brian also told the police that Ana's job had caused her to miss Christmas Eve and Christmas Day with the family. And that Ana traveling to visit her sick mom caused her to miss Thanksgiving with the family. And that he did not want to have an argument with Ana about missing another holiday on January 1st. He had a discussion with her about Christmas Day. He was concerned that by him looking around trying to find her, that she had embarrassed her. So he tells the police, I didn't want to have an argument. So I understood she was going to come back, and she left for that emergency at work. You'll also have access to financial records that will show that Ana Walsh had approximately $200,000 in accounts at Fidelity, and that there was over $1 million in life insurance in Ana Walsh, and that Brian Walsh was the beneficiary of those policies. And in addition to the Cohasset police, the Massachusetts State Police also worked with them on trying to find Ana. You're going to hear from two troopers in particular, Trooper Nicholas Torino and Trooper Connor Keith. They are digital forensic specialists. They have special training in examining computers, tablets, phones. And in this matter, they had the opportunity to examine a MacBook, iPads, and cell phones that were at the Walsh house. And they will explain that on Christmas Day, when Ana had missed Christmas Eve and was, after spending the evening with Mr. Fastow, and was driving up from Washington, D.C., the cell phone that Brian Walsh was using looked up Mr. Fastow on the internet. And that on December 27th, a MacBook that used the Apple ID for Brian Walsh, between 8:30 and 9 o'clock, researched best strategies to divorce for a man, best state to divorce for a man, Washington, D.C. divorce laws. On December 29th, Brian Walsh's cell phone was researching buildings that Ana Walshe managed for Tishman Speyer and emergencies she had handled for them in the past. Trooper Guarino will also explain to you the internet history of that MacBook that had Brian Walsh's Apple ID beginning on January 1st. At 4:54 a.m., the MacBook searched best way to dispose of a body, and then went to similar websites for more than an hour. At 6:24 a.m., same day, the same device searched how long for someone to missing to inherit, how long missing to be dead. Can you throw away body parts? Later on that morning, on January 1st at 9:33 a.m., the MacBook went to search how long does DNA last? And then an article, is it possible to clean DNA off a knife? 30 minutes later, the MacBook researched disposal of a cell phone. At 10:28 a.m., the MacBook researched, I am the user of my wife's credit card. She is missing. And again, on January 1st, at 11:28 a.m., it searched, best way to dispose of body parts after a murder. Trooper Guarino will explain the numerous websites and searches done by the MacBook in the morning and early afternoon on January 1st, and that these websites were about cleaning blood with ammonia, bleach, and hydrogen peroxide. Websites visited included those as whether it is better to throw away crime scene clothes or wash them. One site was entitled, You want to get away with murder? Use a special detergent. This type of activity on the MacBook continued into January 2nd, when it looked up, how long does Lowe's keep security footage? How to saw a body. How to dismember a body. Can you be charged with murder without a body? Can you identify a body with broken teeth? The MacBook also visited websites for apartment complexes in Brockton and Chelsea. One in particular, Chatham West in Brockton. Brian Walshe told investigators that his phone, which was an iPhone 13 mini, had been misplaced and not found until the afternoon of January 2nd, 2023. When investigators examined that phone, they learned that it had been connected to a power source. And it had been unlocked 4 times by either using the face or the passcode. Investigators will also tell you that the location data from that phone showed that it remained in the Walshe residence until the afternoon of January 2nd, 2023. However, there was another phone in the Walshe residence, an iPhone SE, which belonged to one of the children. When investigators examined the location data from that phone, they found that on January 1st, the phone traveled to a Walgreens in Cohasset, then to a liquor store nearby the defendant's mother's home, an apartment complex in Swampscott, to a CVS in Danvers, to a Lowe's in Danvers, and to a Stop and Shop in Swampscott. You will see the surveillance video from those stores. You will see the video from Walgreens, where a white man with dark hair using a credit card buys Band-Aids and antibiotic. You will see on the surveillance video at the CVS in Danvers that a white man with dark hair, now wearing a mask, buys hydrogen peroxide using cash. You will see the surveillance video from the Stop and Shop in Swampscott, where a white man then goes buys ammonia with cash. And you will see the surveillance video from the Lowe's in Danvers, where a white man wearing a mask and dark hair buys several items that cost more than $400 using cash, including a Tyvek suit, and cutting instruments such as shears, snips, and a hacksaw. Investigators will explain how the cell phone location data from the iPhone SE shows that it went to a Home Goods in the morning of January 2nd, and that Brian's iPhone 13 mini went to a Home Depot in Rockland in the afternoon of January 2nd. You will see the surveillance videos from those stores. You'll see a white man with dark hair at Home Goods buying scented candles and area rugs. And you'll see a white man with dark hair at the Home Depot buying more cleaning supplies. 20 pounds of baking soda, mop, buckets, and a hatchet. The investigators will also explain to you that Brian Walsh's cell phone on January 3rd was located near apartment complexes in Brockton. You'll see the surveillance videos from some of the apartment complexes, including one of Chatham West. You'll see someone going to the dumpster and then leaving. The investigators will also tell you that on January 5th, Brian Walsh's cell phone was in the area of dumpsters and a trash compactor by his mother's apartment complex in Swansea, and that this was before he was interviewed by Detective Schmidt later that night. On January 9th, the police went to those dumpsters, and they took that trash compactor and that dumpster to a facility in Peabody, where they searched the contents of both. And they found an Hermes watch, blue-gray hunter boots, a black coat, a COVID vaccination card with Ana Walshe's name on it, rugs, a Tyvek suit, a hammer, shears, snips, a hatchet, and a hacksaw. The police will tell you that these items were packaged and brought back to a laboratory, and they were brought there for examination. And how some of these items were examined for DNA. And the DNA was compared to samples they had from Ana and Brian. Scientists from the state DNA lab will identify DNA of Brian Walsh and Ana Walsh on the Tyvek suit. They will explain that Ana Walsh's DNA was found from items in the dumpster, including drugs, the hatchet, and the hacksaw. Jem Mutlu said goodbye to Ana Walsh about 1 o'clock, 1:30 a.m. on New Year's Day. When he left, she was home, she was alive, she was with her husband. No one has seen her since her husband said she left on January 1st. She has not accessed her finances, her email, her phone has made no calls, and no one has found her body. During this case, we ask two things. The first is that you keep an open mind. Do not rush to judgment, but instead, see how all the evidence fits together. Pay careful attention to the timing of certain events. And second, use your common sense. Don't leave it home. Bring it with you here as you make your examination of every piece of evidence. And at the end of this trial, we will speak to you one more time. And it is at that time we will ask that you find the defendant guilty of murdering his wife with deliberate premeditation. Thank you.
Thank you, ADA Connor. Judge, why don't you take a break and stand up, shake a leg. And when you're comfortable and have regained your focus, you may be seated. Now we'll hear from the defense for the opening statements. Attorney Tipton.
Thank you, Your Honor. Brian Walshe lied to the police. Lied to him on January 4th, lied to him on January 5th, lied to him on January 7th. Brian Walshe went to Lowe's and bought tools. Brian Walshe went to Home Depot and bought tools. Brian Walshe, beginning about 4:54 a.m., began a frantic and tragic search that you'll hear about. You'll hear the evidence of that. You will hear evidence that those searches evolved from how best to dispose a body to even darker subject matter. As he wrestled with the fact that Ana Walshe was dead. That evidence that you will hear will be hard to understand, but it is true. On January 1st of 2023, Jim Mutlow left the family home of Brian and Ana Walshe sometime between 1 and 1:30 in the morning. Ana and Brian Walshe continued to celebrate the news. They went upstairs to the bedroom. About an hour later, you'll hear evidence that Mr. Walshe got up, went back downstairs to clean the kitchen. You'll see evidence that he looked at his email. You'll hear evidence that he then returned to the bedroom, intending nothing more than to crawl into bed with Ana Walshe, the woman he loved. When he entered the bedroom and began to get into the bed, he sensed something was wrong. You will hear evidence that it made no sense to him. But he nudged Ana, his wife. She didn't respond. He nudged her again, a little harder. She didn't respond. He nudged her now in a frantic and panic reaction to where she actually rolled off the bed. You'll hear evidence that now he is panicking and he doesn't understand what has happened and what is happening. It didn't make any sense to him. It didn't make sense that somebody that he had just been with and enjoyed New Year's Eve into New Year's Day would suddenly be dead. Not innocent. You will hear evidence in this case of sudden, unexplained death. You will hear evidence that it is rape. You will hear evidence that it happens in young people and old people. You will hear evidence that it happens in male and female. You will hear evidence that happens during the day and during the night, that it happens to trained athletes. You will hear evidence that it can be the result of both mechanical and or electrical problems within the body. You will hear evidence that it might be cardiovascular, pulmonary, neurological, or other reasons. You will hear evidence that it occurs in people who have never manifested a symptom that something might be wrong. And in fact, you will hear evidence that sometimes the first manifestation that something is or was wrong with someone is the sudden, unexplained death. That's the evidence you will hear in this case. Sudden, unexplained death is known within the medical community and the forensic community. But it is to this day not well understood, and that is the evidence you will hear. And it is not well known to non-medical professionals. And you will hear evidence. Brian Walsh never imagined somebody suddenly died. 1 hour he's with her, he cleans the kitchen, he comes back up, and she is dead. You will hear evidence in this case that Brian Walsh and Ana Walshe loved each other. Yes, there was stress in the marriage. Stress born out of a simple problem that took its toll. And that's the pending federal case that had begun in 2018 and was still going forward. And what happened was, over time, Ana Walshe got a job in D.C. with the support of Brian Walsh. It was a huge stepping stone in her career. It paid twice the salary. And they talked about it, and you will hear evidence that they had to make a decision. Brian could not leave Cohasset because of the pending federal case. So who would take care of the children? Well, Ana worked in D.C. Brian would. And he did. There was stress in commuting back and forth between D.C. and Cohasset. Brian Walsh experienced that stress too. And Ana Walshe and him talked about it. They talked about it on Christmas Day of 2022. And that's what the evidence will be. Yes, there was an affair. You will hear evidence of an affair. An affair does not make someone a bad person, does not make someone a bad mother. Make no mistake about that. But yes, there was an affair. Not between Brian Walsh and anyone, but between Ana Walshe and William Castor. The evidence in this case will be that Ana Walshe did everything she could to hide that affair. That she did not tell her closest friends, her confidants, some of whom lived in D.C., the same person, Alyssa Kirby, that she spent December 29th with, drinking and talking about her life. She hid the affair. William Castor will tell you that he was unaware of any plans of Ana ever telling Brian about the affair. William Castor will testify that they behaved differently in public in D.C. to make sure there was no appearance of the affair. William Castor will testify that Ana Walshe told him she would be devastated if Brian ever learned about the affair. Brian Walsh didn't know about the affair. He did know. Ana Walshe had a crush on William Castor because she told him. And he did not react in a jealous way. And you will hear evidence that over the close to decade that these two people were in love. And all you have to do is look at the evidence and the photograph you'll see of Ana Walshe. And the evidence will establish she is a beautiful woman. And it was not unusual for her to comment to Brian, I had some man look at me today. I think he liked me. That didn't upset Brian, not over a period of 10 years. And when she told him that she had a crush on William Castor, the man who had sold them the $1.3 million townhouse in D.C., it didn't upset Brian. He trusted her. In fact, you will hear evidence from Melissa Kirby that Ana Walshe told her, "I wish you would be jealous." You will hear evidence that there was no financial issues or problems. Ana Walshe just got that job in the early part of 2022 that paid close to $300,000 a year. They owned that townhouse in D.C. It was worth over $1 million. They owned whole life insurance policies on their sons in the amount of $1 million each. Whole life that you will hear you can borrow against if you need cash. You will hear evidence that Brian Walsh's mother gifted them money, and actually you'll hear from the landlord of the home that they were living in at the time that Brian was living in, taking care of the 3 boys while Anna worked in D.C., that it was his mother who was paying the rent, because that's what grandmothers do. There was no financial problems here. They owned investment property in Massachusetts. The evidence in this case is that Brian Walshe loved Ana Walshe. You will hear that she spoke of him in glowing terms to William Fester. That she said, "I want people to see the Brian that I know." You will hear how she talked about her relationship with Brian with Melissa Kirby. And notwithstanding the fact that Ana Walshe was having an affair, she described their relationship as open and honest. He believed their marriage was open and honest because he loved her. You will hear how she described Brian as her best friend to her friend Alyssa Kirby. You will also see evidence of text messages that you may use to determine for yourself if there was love between these 2 individuals. The importance about those text messages that you'll see is simply that they're dated. The ones you'll see are dated beginning December 25th of 2022, 7 days before New Year's Day. On 12/25, Ana Walshe and Brian Walshe are texting each other, and she is sending him 7 properties, listings, primarily out of Zillow. 7 listings of properties in the greater D.C. area. Bethesda, Annapolis. They're searching for future investment properties for the future. You'll see that, and you'll hear evidence that then she comes up to celebrate Christmas with Brian and their 3 beautiful boys. You'll see on 12/27, now that she's back in D.C., these text messages between them. And they're talking about one of their properties. And they're talking about the fact that it, in fact, sold. So now they need to figure out what to do with the proceeds. You'll see on 12/28, text exchange between Brian Walshe and Ana Walshe. Now, she's back in D.C. She's not feeling well. She's telling Brian, "I don't feel well, so I'm going to stay at home and work at home today in D.C." And they joke. And on the text, Brian says something like, "Well, I guess I'll have to get you a plunger." Anna responds, "I'll tell you what. I'll buy the plunger. you buy me that Porsche. Why? Because Ana Walshe wanted a Porsche. And what you see on that text exchange, right after she says that, is you'll see postings that he sent to her of the Porsches he'd been shopping for the woman he loved. And you'll see in his manifesto that he was shopping for Porsches because she had asked for one. On 12/29, you'll see a text exchange between them where they're talking about a 3-story brownstone that she had found that maybe they'll buy for investment. And you'll see the text references to how much it cost, the square footage it's up and below. You'll see text exchange between them where they're talking about possible renovations in the future. They are talking about the future. And this is on 12/29. And then on 12/30, simple texts between them about her catching her flight from D.C. to get to Cohasset for New Year's. She texts them, I've landed. Then what you see in those text messages are she begins to send Brian pictures of her playing with the boys now that she's reunited with the 3 beautiful boys again. And then you see 7 pictures sent by Brian Walshe back to Ana, taken of her playing with the boys. And how do they sign off these texts? You'll see them. Brian says, love you. And Ana Walshe says, love you too. We've come full circle in this opening, and now we're back to New Year's Eve. And Jim Mutlow, the family friend, is invited by Ana to come to the house to celebrate New Year's Eve. You'll hear evidence that he was thrilled. He was thrilled to be with 2 people he'd known for years, but he hadn't seen in some time. He knew their kids, 3 beautiful boys. He'll describe how when he drove up in the driveway, Ana Walshe ran down the driveway in her heels, no coat, on a cold winter day, to hug him. And then what happened? They all went into the house. And what was occurring in the house? Brian was cooking. New Year's. He was feeding them as they all talked for 4 to 5 hours. And what were they talking about? They were talking about the future. They were talking about investments. Ana Walshe told a story about how Brian had found a ring for her and the whole adventure of finding the ring and buying the ring. And she talked about it in glowing terms when she talked about how Brian did that. Mr. Mutlow will describe that for the 4 or 5 hours that he was there, he saw no problems between them. He said that Brian was happy and Ana was happy. He described the atmosphere as jovial, festive. He described it as loving. As adults do for New Year's Eve, they celebrated with wine and champagne. You will have that box, or at least photographs of that champagne box, where they signed it. And what Ana signed on that box she wrote, "Let's make 2023 the best one yet." She went on to say, courage, love, perseverance, compassion, joy, and signed it, love, Ana. Nothing was more important to both Ana and Brian but those 3 beautiful boys. They had talked about the problem of the federal case. It was stressful. When you heard in the Commonwealth's opening the reference to a divorce search, please understand that the other evidence will be that that singular search occurred between conversations between Ana and Brian about the sale of their property. You'll see that that search about 8:30 on 12/27. And why is that important? The evidence will show that the only time Ana Walshe talked about divorce with William Fastow, she talked about it in terms of Brian and I attempting to preserve the family assets. Why is that important? Because yes, there was $400,000 of restitution that was going to come due. And yes, Brian may have had to go to prison for some time. And what did that mean? It meant that there was going to have to be arrangements, not just to pay the money, which wasn't going to be a problem, but the boys had to move up to D.C. because Brian could no longer take care of them. And there would be all that added expense. And they went so far as to talk to Robin Howe, their nanny, their babysitter, and asked her if she would consider moving up. So there were expenses. So when you talk about preserving the family assets, you have to decide, how is it that I make sure, how is it, as Brian Walshe will tell you, how is it that I make sure that my wife and my 3 sons are financially secure if I have to go to prison for a day, for a week, for a month, or for years? That's what they were talking about. And in all of the other digital data that the Commonwealth has been poring over for 2 years, you will not hear evidence of any other conversation about divorce. And you won't hear it from William Fastow. In fact, William Fastow will tell you he had resigned himself to think Ana Walshe was never going to leave Brian, father of their children. Jim Mutlow left around 1:30. Brian Walshe and Ana Walshe went upstairs. He went back down to the kitchen about an hour later to clean it up. And then the impossible, the unimaginable happened. It didn't make sense to Brian Walshe. It was confusing. He never thought anybody would believe that Ana Walshe was alive 1 minute and dead the next. And all he could think about were those 3 boys. What would happen to their 3 boys now that Ana is no longer here? What will happen if they think he did something bad to Ana? Where will those 3 boys go? And so, he told the story. He told lies. He tried to hide so he could hang on to those boys. Brian Walshe never killed him. Brian Walshe never thought about killing him. Never think about that. Brian Walshe is not guilty.
Once again, why don't you stand up, shake a leg. 15 minutes before the break.
All right, so that's openings. Those were the openings, played openings again, and we're just waiting for live court to kick back in. So... Lazy boys, wrong chat. I know. It happens. It happens. Judge said she was going to give them until 10:30 or 11, and here we are almost 11. So let me pull this up. Then we'll just watch this for a few minutes. If they don't come back in like 5 or 10 minutes, I'll go ahead and I'll play something else. We'll just hang here for a few minutes, and then I'll try and find some pretrial stuff we didn't watch. A lot of empty promises. I agree. There was he said a lot in there. He said, "We'll hear this. Well, the evidence will show this." Not hearing from Brian, I think, was a big mistake. But that's just me. I think it was a mistake on his part because now the jury's left with all these questions, and unfortunately, we're not going to be able to. We'll never know. We'll never know what from Brian's side. We'll never know. Let me just make sure I'm live, which I think we are. Yep. All right. So we'll just hang here for a second. That's Sherry. That's what the judge said. That's what we're waiting for. If the feed had ended, I would have, if the court feed had ended, we'd be watching Dustin Duran here. I would have ended this feed and we'd be focused on Dustin Duran, but they still have a feed. So to me, they're going to come back with the charging conference, the jury instructions, all that good stuff. But by all accounts, they're going to be done. If they come back at 11, which is now, they should be done within an hour, 2 hours tops. 2 hours tops. So, Kathy, I like hanging with you too. Thank you. Joanne, heading to the kitchen to make coffee, shall return with a tray of coffee and cookies. Nice. Sparkling Princess, so aggravating. Not that we would believe him anyway, but I want to know what he had to say still. Very frustrated, very aggravating, especially Tipton throwing down all this stuff. And we didn't hear anything. So Crazy Mary Jo, we wouldn't ever know if he testified. Lying liars lie. Yeah, that's true. Hey, Shirley, welcome back. Mallory, I wonder what happened. Yeah, what made him change his mind? I don't know. Kia, they already did the charging conference? Well, then jury instructions, aren't they? Isn't that the same thing? What are we waiting for then? I know that she sent the jury home. So what are we waiting for? We're waiting for something. I thought jury instructions. That she was going to go over the jury instructions with the two parties. I think that's what we're waiting for. Please tell me that we're waiting for something. Something, positive. Not just looking at this fan. Well, we do have Dustin Duran on if you guys want to go check that out. Sparkling Princess, Tipton came in with a fight and left with a mess. Yeah, he came in, today he sounded very defeated. He was very defeated when she said, is your client going to testify? And he's like, no. And she's like, what? Speak up. Like she had, Judge had to ask him to speak up because he was so, he was so defeated, in my opinion. He sounded very defeated. And then she's like, are you going to call any other witnesses? And he's like, no. And she's like, well, I did all this work last night. So I don't think she was too happy about that, but it's her job. She has to, Richard, yeah, that's what she said. Attorneys are reviewing it before coming back. Thank you, Richard. And Kia, yes, she hasn't done jury instructions yet. Okay. Amy Lee, yes, very defeated. Yeah, Richard Tipton looked that way. WGWI defense lawyer looked tired out. Agreed. He expected Brian to testify, Shirley says. Sherry, he looked defeated yesterday too, yeah. Well, I guess as an attorney, you have, the strategy, you have these ideas, the strategy of like how the trial's going to go, and you work and you work and you work hours and hours and days on it, and then your client says, yeah, nope. And then that just throws everything for a loop, I guess.
Thank
You see, go to down session, shut up yourself.
Your Honor, we're back on the record in the matter of the Commonwealth versus Brian Walsh, indictment 2023-0091.
All right. Let me make some space over here. So I know you haven't had a long time to look at them, but we'll take a stab at seeing how far we can get today, and then we'll reassess whether we need to charge conference a little bit more tomorrow. All right? So my approach to charge conferences is pretty informal. And so what I'll ask for each of you to each side is, based on your initial review of the draft, where's the first page that you wish to either bring something to my attention because you either don't want it in there or you want it in a different way? So an edit or an extraction or an addition. What's the first page for the Commonwealth?
Your Honor, I'd say page 15 going into 16, the impeachment by prior conviction.
All right, stop right there. And does the defense have anything before page 15?
Number one.
Page 1?
I think it is. She just took it.
Are you joking?
No. It's, I'm sorry. Premeditation. I'm sorry. Notes are saying it's paragraph 1.
I said page 1 is the index. Actually, it's not really page 1.
No, we'd be here forever if we were starting with pages.
All right, so what page?
Page 6, and I'm just lodging my objection, Judge, to otherwise the instruction complies, in my opinion, with the model jury. I'm renewing my request for my modification that I filed on behalf of defendant's request for jury instructions concerning consciousness of guilt, emotional evidence, and bad acts. Paragraph 1, I am asking that the section be regarding the timing of premeditation be removed for the reasons I stated in the motion.
All right. I read your motion. Denying your request to make the change. As you know, if I agreed with you, I guess the underlying premise that I thought there was something wrong with that instruction, I agree with you. These are just model instructions. Now, they're model instructions that people have spent, I don't know, countless hours assessing the propriety of, but I don't think that that instruction is improper in any way. I think it's a proper instruction, and it's one that ought to be given in this case. So I won't modify the model SJC instruction with regard to the request, but it's been fully preserved for the appeals court if they decide to change the instruction.
Thank you, Judge.
Mm-hmm. So 15 on to 16. Anything from the defense before page 15, other than what you just mentioned?
Page 9.
Yes, counsel.
The instruction, parentheses B,
yes.
Use of a dangerous weapon.
Okay.
I think that's in the context and circumstances of this case, that instruction is very prejudicial and misleading. There is no evidence no direct evidence or circumstantial evidence that there was a weapon used that caused the death of Ana Walshe. And so what the jury is being allowed to do...
What about the breadcrumbs that the Commonwealth put down?
What, the breadcrumbs?
Well, why don't you argue, and then I'll let them... I don't want to make their argument for them. That would be... But I want to get to the right answer. So go ahead and you argue, and then they'll argue, and then you'll have an opportunity to rebut.
I understand the admission of the exhibits, and I understand the admission of the hacksaw, but to suggest to the jury that they can just pick and choose whatever, quote, weapon, even if you can define it that, and just speculate as to, well, this was used, this wasn't used, that is requiring the jury to speculate that a weapon was in fact, in the first instance, that a weapon was in fact used when there's no evidence of that. And secondly, to speculate that some of the evidence that was introduced might have been a weapon that was used without any evidence that in fact it was. And given the state of this evidence, this instruction invites the jury to speculate without sufficient evidence to reach its conclusion, and I would ask that it be removed because all it does, well, I'm repeating myself. I'll leave it at that.
All right, Commonwealth.
Your Honor, it suggests from the evidence it's a reasonable inference based on the safari history and the searches regarding getting DNA off of a knife, using a dishwasher to remove DNA. One can infer that an object was used, a dangerous weapon was used to murder Ana Walshe. There's also the evidence of the defendant's trip to the Vin and Liquors dumpster when the liquor store was closed. I believe the manager of the liquor store identified it as the defendant throwing that bag in the dumpster. That's prior to the trip to Lowe's or any of the stores where he purchased the materials. I would suggest it's a reasonable inference that a dangerous weapon was used here and would ask that the court keep that instruction in.
I might have misheard, but I thought I heard Ms. Cusick say DNA on the knife.
No, she didn't say that because there is no DNA on the knife, right?
That's correct, Your Honor.
So, but I did hear you say knife, didn't I?
Knife. I didn't hear her say knife just now.
There was a search.
There is a knife above the...
There is a knife, but there is also a search in the web history in the defendant's...
I remember that. And
regarding...
the search was specific, as I recall it, and remind me if my memory is wrong. Is the search with regard to the dishwasher specific to a knife?
Your Honor, may I? I believe that I can answer this question.
There is a Slate.com article
Right.
that the defendant went to that was regarding getting can DNA be removed from a knife.
Yes,
Then the dishwasher is
following that, right?
it follows that, and it's can the dishwasher, and I'm just trying to find the exact words.
Give me the page number on the, I think it's Exhibit 79, is that right?
It's Exhibit 79.
All right.
And then page number 4, the DNA off of a knife,
Yes,
is page 578.
let me get there.
Okay.
I'm there.
Okay. Then if you go to page 670,
Hold on, I just want to look at these.
sure, I apologize.
How long does DNA last? Is it possible for DNA to take DNA, clean DNA, off of a knife? And that's done on 1/1/23 at 9:34 a.m.
Yes, Your Honor.
Okay, and just putting all this evidence together, when was the Vinton's liquor is also on the first? It's at night because I remember it being a little dark. What
Yes,
time
Your
is
Honor.
that?
It's dark at the at Vinton Liquors.
5:30, 4:30, something like
5
that.
p.m., Your Honor.
All right. Okay.
And so if you were to go to page 670,
Yeah. Let me get there. Yes.
and if you were to go to record 2430,
Does the dishwasher clean blood?
yes, Your Honor.
That's at 1/1 at 1:52, also before the,
Been in liquors.
right.
And then on page 671, there is record 2433. Is it possible that a knife that
Which had blood on it remains contaminated with HIV after it's been washed with hot water and dishwasher soap.
Yes, Your Honor. And so,
And above it, does the dishwasher clean blood?
yes, Your Honor. So I think earlier you referred to breadcrumbs.
That's what I said.
And so our position would be it's a reasonable inference based on the searches, the behavior of going to Vinton Liquors, and then this is all before the Lowe's trip, where the other articles are bought for the purposes of the dismemberment. And if you look into the searches on the second, it's instructions on how to dismember. So there, I see what our argument is that those searches show the reasonable inference that a weapon was used.
All right. There are the breadcrumbs. Attorney Tipton, back to you.
Well, I'm not going to repeat what I said. I understand the breadcrumbs argument. However, I would ask then, I think I see the writing on the wall, that the instruction will remain, but I would ask then, to be fair and balanced, that a sentence be added, that you are not to speculate about whether a knife was used, or words to that effect, to help guide the jury to avoid speculating about any and all of the tools and weapons, so-called weapons. I just think the jury's going to think, oh, I can cherry pick whatever I want to and call it a weapon and use it to find the defendant guilty of first-degree murder. And I'm trying to make sure that the jury does not get such a broad instruction that allows them to speculate. So I'll leave it at that.
Well, I'll give some more thought about whether I add some language in there with regard to speculation, and if you wish, you can provide me with some recommended language. But as you know, the whole issue with speculation is handled quite completely in other parts of the instruction. But I'll think about it.
I will send the court, if it's okay, I'll send an email to the court today with suggested language.
All right. as of this time, the instruction is going in and subject to any additional edits. But I think there's enough there that the Commonwealth has presented, as I said, the breadcrumbs. Which, I don't, this case is what it is. It's been a circumstantial case from the beginning. And so those breadcrumbs are important for the Commonwealth's case. And I think they've properly established it to a sufficient degree to get this instruction about use of a dangerous weapon. But I'm also mindful of what you say. I'll go back and look at the section about the prohibition against any speculation or guesswork and see if I feel like it accurately and completely addresses those concerns. And I'll be open to seeing whether there's something else that needs to be added to make it more easy for the jury to digest this aspect. That's all I can say right now. All right. We're still at the defense. Anything else before page 15?
No.
All right, so now we'll move to the other side. What is your, I'm moving to page 15. Did you say 15 into 16?
The impeachment by prior conviction?
Yes.
And
I guess I lifted part of this language from the defense's request.
Your Honor, this appears to have language suggesting a testifying person being impeached.
That's probably because when the defense, I lifted it from your instructions, and at a time when I think that was the expectation, but let me go back. Well, that first sentence, they have heard evidence through a stipulation, right? Is it later than that I only read the first sentence so far. You've heard evidence they have through stipulation, right?
Yes, Your Honor,
That sentence is okay.
It's on the next page only for the limited purpose, and I suggested limited purpose.
I see. So does the whole thing come out?
Your Honor, I note in Commonwealth's motion in limine number 12, paper 198, the Commonwealth laid out the purpose for which it was seeking to bring in the evidence of the federal charge. Mm-hmm. Perhaps that language from that could be substituted, as you may only consider this evidence to understand the relationship between the defendant and the victim, or something of that nature, to understand the complete circumstances of the situation in the home at the time of the events at issue here.
Well, I don't like that.
I think, Your Honor, the model instructions all do seem to include you may only use this for the limited purpose of, and I suggest they should be given a purpose. And
well, but it's not impeachment. I mean, I did put that in there last night based on the information I had at that time. But that prior felony conviction is no longer impeaching Mr. Walsh. So it just seems to me like it should be out.
We think it should be out.
Maybe it should be out.
I mean, it's no longer impeaching him, and the relevance of the prior federal conviction goes to motive intent, it seems to me, right?
Your Honor, I suggest there were reasons it was introduced to understand the relationship in the home as way of a shorthand. So, but I agree, it is not impeachment evidence.
All right. My present ruling is that whole section's coming out now. The reason the impeachment by prior inconsistent statement is now in italics is I'm sure that happened with some witness, but I'm not 100% sure.
I don't think it did. At least,
anybody?
I don't want to speak for you.
Your Honor, I think some witnesses may have testified a little bit differently than they had previously and were shown documents. I don't know that it rose to the level of impeachment, but there was some questioning of some witnesses about something they had said previously.
Yeah, I just don't think that we ever got to a statement. I don't remember anybody grabbing a grand jury transcript and cross-examining. The closest we got to it, I think, was Jem yesterday, Mr. Mutlu yesterday, and that wasn't with a prior statement. It was his prior statement, but he just said, I don't remember. So is that enough to warrant the instruction?
Certainly, if the defense wants it out, we agree we should take that out.
I don't need to give them more instructions that they're wondering, what the heck is she talking about? So I'm inclined to take it out.
And we have no objections.
All right, that's why it was in italics before.
Your Honor, then the impeachment by defendant's prior bad act.
Yes.
With this, I would suggest that the lying and the conveying of the body are part and parcel of the murder at this point. It's the disposal of the evidence of the crime and the lying about what he had done. I would suggest it's not a prior bad act. It's part of the evidence of the case.
It's an interesting question.
There's many interesting questions in this case, Your Honor, no doubt.
It's an interesting question whether, where are you drawing the line of a prior bad act occurring? Can you have a prior bad act that's part and parcel? Is it prior to this time? Is it prior to the crime that was charged?
It's arguably subsequent, Your Honor, but...
Right.
I mean, it's arguably...
What about the lying to his federal probation officer?
That would appear to be a bad act, arguably a subsequent bad act, but...
Yes.
I don't want to interrupt. I tried to address what I believe are prior and subsequent bad acts in our pleading at page 6. And I took it from the Massachusetts Jury Trial Bench Book, and I modified it only to accommodate what I believe is relevant and pertinent. And the gist of that model instruction is to make sure that the jury, if they hear what they consider to be bad, and I frame our instruction as prior and subsequent bad acts, that he's not charged with those, and that they have to, just like the model instruction says, if they deem those to be bad or subsequent bad acts, they can only use them for a limited purpose. And I think that this jury will probably be asking themselves, I don't know who in the world wouldn't ask themselves, that's a bad thing to do, if they believe that the body was dismembered, and if they believe that the body was disposed of in bags, anybody's going to think that's a bad act. And they need to be instructed that they can't, he was not charged with anything, and therefore they can only use that evidence in a limited basis. And I don't much care for the specific language of motive or anything, but it is the model instruction, and I think I would try to parse.
So I'm looking at your instruction right now, and that really deals with the art fraud, right? Are we on the same page,
yes,
Attorney Tipton? But are you suggesting, I just want to make sure I understand what the respective positions are. Are you suggesting then that you want to expand that, so you want an instruction to the jury that includes the language that I have in there, which is lying to the police and disposing of the body of Ana Walshe?
Well,
and the lying to the probate. So that's not what's in here, but are you saying do what you did, Judge, in the instruction, but add what I want in instruction 6? Is that what you're telling me?
Yes.
Okay.
But
do you want that to be included So in the proposed instruction, and just so the record's sort of clear, I'm talking about the defendant's request for jury instructions concerning consciousness of guilt, emotional evidence, and bad acts. I don't know what the docket number is, but I got that. It was filed yesterday, December 10th. And I'm looking in particular at your request number 4, prior and subsequent bad acts. That's what you were referring to, Attorney Shipton. Okay, and so in that, as you initially drafted it yesterday, it was about the art fraud, but you're now suggesting that that would be an appropriate instruction also for the other bad acts that I've identified in my draft on page 17 under impeachment.
Yes, Your Honor. I was anticipating there to be a proposed other instruction like you had, but yes,
okay.
I would ask then that.
So I think I understand what the ask is now.
Right.
And so now I'll go to the Commonwealth.
Your Honor, I think I understand it better as well. It also says in the instruction about the middle of it, if you credit the statement, I don't know that we're specifically talking about a statement here. And maybe that could be expanded if the court is inclined to keep that instruction in.
Well, I think the language comes in that defendant hasn't been charged with committing any other crimes other than murder. I'm just pausing there because if I move the federal art conviction in, somebody could wordsmith that and says, oh yes, he pled guilty to a federal crime. Maybe the better way to say it is the only charge you need to consider is the present charge of murder. You looking at the first sentence?
Yes.
Let me take a minute. All right, so if I say something along the lines of, the only charge the defendant is now facing is the charge of murder. You've heard mention of other acts allegedly done by the defendant, namely, and I wrote a few things in there, and it would seem to me what the defense is asking is that I add, the language that you have in your request was including acts involving a federal case concerning art fraud that he was charged with in 2018 and sentenced in 2024, comma, I'll just put them in date orders, right? Lying to the police and or disposing of the body of Ana Walshe and or lying to his federal probation officer. So all 4 things would go into that parenthetical.
Good.
Okay, and then I would pick up with what the defense has. You may not take the defendant's prior acts as substitute proof for that they committed the crime charged, nor may you consider them as proof the defendant has a criminal personality or bad character. And then the rest of that, you see that all there. All right. What do you think about that, Kamala?
Will the court be removing the, but if you credit the statement sentence?
Yeah, no, what I would do is, so I'd make the change that the only charge the defendant is now facing is the charge of murder. You've heard mention of other acts allegedly done by the defendant, namely, and then I would go to the defense's suggestion, namely, acts involving a federal case concerning art fraud, and that he was charged with in 2018 and sentenced in 2024, semicolon, lying to the police, semicolon, and or disposing of the body of Ana Walshe, semicolon, and or lying to his federal probation officer, end parentheses. Then pick up with the defense's request and follow that through the end. You may not take blah, 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 right through to, it would be extremely unfair to consider this evidence for those purposes. That's where I think I'll end it.
So you're not,
Then I go back. I don't think that's appropriate to add the "for one thing."
the last two sentences?
That's right.
I will just say, Judge, that those sentences are contained in the model instruction at page 343.
I'll take a look at it, but it seems to me then if I put that thing in there, then I've got to. No, I don't know what I do about the other things, because you can see the issue that raises.
Your Honor, there's also the possibility that maybe this instruction should be given around the same time as the consciousness of guilt, because it almost seems, I don't have them both right in front of me, but it almost seems like we might be telling the jury different things about how they can handle the evidence of lying to police and the conveying of the body of Ana Walshe.
Well, that consciousness of guilt is before here, isn't it? Maybe.
I believe it's on page 27.
Oh. Well, I had this all in this section because I thought I'll put the 3 impeachment things, but now 2 of them are gone, so it doesn't make any sense, I suppose, standing alone. Maybe we just go straight from witness credibility to experts, which makes more sense, and move this impeachment paragraph later in the instruction. What do we think about putting it either around the vicinity of the consciousness of guilt instruction?
Well, my comment would be I'm objecting to the consciousness of guilt, so
I know you are. I know you are. It seems to make more sense in that area. So, I'm going to move it probably before or after the consciousness of guilt instruction, somewhere in that vicinity. And if you have any strong preferences, you let me know when we get down to page 27, recognizing you don't want it at all. But I'll edit the impeachment to include a substantial portion of what the defense has requested and add in specifically the federal case. That's all I can tell you for now. To be continued on tomorrow if we need to discuss it more.
and I understand the court's not going to include the last 2 sentences, so I'll just lodge my objection.
Okay. So lodged. What's the next edit that the Commonwealth has?
Commonwealth has page 27.
What's the next edit the defense has?
27.
Nobody likes penny 27. What did I do on that page? Let us see. Okay. That's COG. Who wants to go first with what I got wrong?
Your Honor, I would suggest here in the italicized language,
Yes.
In the course of the trial, there was some evidence suggesting that the defendant may have intentionally made certain false statements before his arrest, and that he may have taken steps to conceal the disposal of Ana Walshe's body. I would just suggest that that should be tried to conceal the disposal of Ana Walshe's body. And in the...
Well, the fact that it was unsuccessful is something you can argue. I mean, there is some evidence that he may have taken steps, right? That's not inaccurate.
Correct, Your Honor, that's accurate.
But what do you want me to add?
I was thinking you could subtract some words and perhaps make it more concise, but that is certainly
All
accurate.
right, so what do you want me to subtract?
Rather than saying taken steps to conceal the disposal of Ana Walshe's body, it's tried to conceal Ana Walshe's body. It's not so much that he was concealing the disposal of it, he was concealing the body itself.
So you want me to taken steps to conceal Ana Walshe's body after death?
Yes, Your Honor, because it's the body itself. It's not so much the concealment of the body, but it's the steps to
conceal the
disposal
body,
of it.
not
Yes.
the disposal of the body.
Yes, Your Honor.
All right, that's probably more accurate. So under the Commonwealth's request, I would delete the 3 words, the disposal of.
Will you add the word tried?
What do you want me to add?
Tried. I thought I heard the Commonwealth asking for tried.
Commonwealth's content with how the court articulated the...
Well, attempted to take steps might be consistent with the evidence, but then that puts my thumb on it a little bit because it presumes that that was evidence of her body.
All I was responding to was the Commonwealth suggested the word tried. I think that is more consistent with what the evidence shows. I'm just talking about tried, not waiving any argument to the Constitution.
All right, I'm going to leave it like it is with the removal of the disposal of. I don't like the tried part.
In the next paragraph, Your Honor, in the italicized, defendant did attempt to provide false information. I believe it would be did provide false information.
And there I got the language right in the second attempt in terms of what you just pointed out in the earlier paragraph. Even a blind squirrel finds a nut every once in a while. All right, any other edits to that consciousness of guilt instruction? Recognizing the defendant doesn't want it, and that objection is noted and lodged.
Are you done?
I think she's done.
So, once again, I refer to our prior pleading. And on page 4,
Yes.
I'm asking that be included. And I modeled that trying to find the citation. I modeled that after what I believe to be the gist of a supplemental instruction 9:22, and it's the district court. And the heading for that supplemental instruction that's included refers to where evidence is of it, where such evidence is of another crime. It goes on to say, I caution you in considering such evidence that the defendant is not on trial for, and then it has a blank intent,
Right.
and that's what I do.
But now that I'm moving down the other section that we just discussed, which far more in a more detailed fashion addresses that.
You mean in the prior?
Yes, because now that's going to sit right on top of this one.
Well, but I think that The reason I'm pressing this, notwithstanding this other instruction, is because I think just the title alone draws attention to the jury, where they're hearing a different instruction entitled consciousness of guilt. And I don't know that jury will take some language from a prior instruction and import it into this one. And it's important for them, in our opinion, to have context for how they use so-called consciousness of guilt evidence. And the other thing is, when you talk about consciousness of guilt evidence, the case law is clear, and the instruction says they can't rely on consciousness of guilt evidence alone. And I think it then, since we don't want the instruction in the first instance, at least it gives them better context for how to apply what they may deem to be consciousness of guilt evidence, especially where you hear all of these other acts. And yes, they will get the prior bad acts if you juxtapose it before this instruction.
I actually think it's better right after it, as I'm thinking about it, because it leaves them with it puts them in that moment, and then you may not use it for this purpose. As you were arguing, I'm like, that's not going before, it should go after.
Right.
Because
I'm just pressing this supplement. It's primarily based on this Model 9.
I'll go back and look at it, and I'm going to see how it feels once I've moved things around and how it reads. All right?
Okay.
And of course, you know this is coming, so you will, I am sure, as you all, I know you will. You're going to take those parts of my instructions that you want to highlight to the jury and put them in part of your closing arguments. And so you'll know where it is, and you can point directly to it so that you highlight. I'm going to tell them, take all my instructions as a whole. You're going to drill them into the ones that you think best suits your client's argument, including this one. But anyway.
I may, but...
or not.
Having said that, I guess I just want to ask a question.
Yes.
Does the court intend to supply written instructions to them?
So what I do is I don't give them a written instruction during the actual charge. And there's a very simple, I'm a very practical person. I've been sitting on the bench now since 2017. And not once, and I'm not proud of this. There are other judges that do a better job at this. There's not once, no matter how many times I read this, no matter how many times you read it, there's always a wayward S that sticks in there, charges instead of charge, or some other less than perfect product as I read it. And I edit those on the fly, and I tell them, typically, it's my oral instructions, not what you put in the writing. I've never had something that's been a huge guffaw, but it could happen. I don't think it's going to happen in this case. But I don't finalize those instructions until after I've read it to them, made those edits, and I sort of a running game I have with myself. When are you going to get it right? Exactly right. It hasn't happened yet. I don't know that it's going to happen on this case. There's always some little niggling little mistake. So I don't give it to them in writing when I'm reading it. I give them copies of the charge when the exhibits go back. And my practice has sort of varied over the years. I used to just send in one because I want them around the table talking about the instructions, doing it all together. That became cumbersome, so I've now changed it. I usually send in 5 or 6 copies of the charge. If they want more, they can have more. I usually tell them that. But I won't give them, they won't be sitting in the box reading the charge with me. That's not how I do it, and that's the practical reason why I don't do it. I don't want to be backpedaling. I want to give them the best product, both orally and in writing, that I can give them. So if that answers your question, that's how we'll do it. Now, you'll obviously have the draft so you can read along. And I encourage you to point out my errors despite my best efforts. You'll see me up there marking it up, as I always do. Maybe tomorrow will be the case that I get it all right. Still trying. All right, what's the next page?
Your Honor, for the Commonwealth, not so much a page, but circumstantial evidence. I know the court has direct and indirect evidence in there at 23. Would the court consider also including circumstantial evidence in that?
What page you on?
Page 23?
Well, this is the plain language version of the circumstantial evidence.
Yes, Your Honor.
I don't have strong feelings about it. If there's some language you want to propose, I have used other language that refers to things as sort of the more old-fashioned language. This is direct evidence. The mailbox postman thing, I've delivered that a number of times. I think this is the more modern version of that, but if you want to propose some language, I'm not adverse to explaining it.
I'm just objecting to any additional language, and I'll wait and see what they propose. But
All right.
I think this is sufficient.
It just talks about it in terms of direct evidence and indirect as opposed to circumstantial. I mean, it could be as simple as adding in sometimes called circumstantial.
Yes, Your Honor. With permission of the court, could the Commonwealth submit something later today?
Sure, that'd be helpful.
And if they do, which it sounds like, excuse me, I'm going to then add, just to let the court know, an additional language as for inference that hopefully will counter what they're trying to do. But I'm just giving the court a heads up. I don't want to send you something and you ask.
How about if I just say that is indirect evidence, sometimes called circumstantial evidence, and then you don't have to do anything this weekend. I mean, not this weekend. It feels like that's the weekend. Then you don't have to do anything tonight. Well, I'm going to suggest that, but you can do what you want. All right. Anything else on the instructions?
Not from the Commonwealth.
All right. I really didn't mean to set off well, there's a word that comes to mind, but it wouldn't be judicial, so I won't use it. When I made my comments this morning about closing arguments. So let me just say, I'm always trying to stay a step ahead of you. It's not easy. And so I did start looking at this issue a couple of days ago. And I'm going to tell you what the cases I came across and sort of where my preliminary thinking is with regard to this. And maybe there isn't an issue. Maybe there is. But let me just tell you, we all know what I'm talking about, right?
Yes.
Yes.
All right. So I'm going to give you some cites to some cases, and I'm going to tell you preliminarily where I think the line drawing is. And it's really preliminary, because I looked at these like 4 days ago. Oh, Tuesday, December 9th. So I guess it was just yesterday.
2 days.
Well, no, that's not exactly when I looked at them. I think I looked at them this week, and I sent them to my law clerk on Tuesday, December 9th, or vice versa. So anyway, here are the cases that I want you to take a look at. 2019, Commonwealth versus Ahern, 96 Mass App Court, 197. And that cites to Commonwealth versus Nelson, 468 Mass 1, a 2014 case from the SJC. And I also want you looking at Commonwealth versus Tavares, 27 Mass Appellate Court, 637. And in those cases, the SJC and or the appeals court is really talking about this issue of improper burden shifting and avoiding that in closing arguments. And really, it seems to me the one that's the closest to this is a combination of Ahern and Nelson. And look at those cases. I'm not going to get into a detailed description of what I think the similarities are to those cases. You're going to see it when you read those cases. But it seems to me preliminarily that while the Commonwealth should not comment that the defendant didn't testify, that would be improper. It seems to me that they could point out that there's no evidence that Ana died of any natural causes. I read the pleadings that just came through. And if that is where the line is drawn, and you don't have to respond to this right now. I'm not, and frankly, the pleadings that just came through, I mean literally the ones that came through before the defense filed right before I went on the bench. I'm not sure for the allegations of reneging on a promise are impacted. But I'll qualify that by saying I read the pleading quickly and thought to myself, well, I didn't mean to start that. Back to how I opened this discussion. So that's where I think the line is drawn by those cases. And knowing that's where I sort of am drawing the line, take a look at those cases, and we'll discuss it again before the before the closing arguments.
Thank you, Your Honor.
Just to be clear, I think and we'll read the cases, but what the court's saying is that you would think the Commonwealth could comment that something about
there is no evidence that Ana Walshe died of natural causes.
And of course the defendant can make his, I just want to be clear about this because I think we might reach some common ground here.
That's what I'm trying to achieve.
and I'm responding to something that the Commonwealth represented I'm not going to go into right now. So let's just stick to this, if we may. So if the government's allowed to say what I just said, and of course the defendant can argue there's no evidence that there was any homicide or any...
Expect you're going to.
I shouldn't be here, I suppose, but I can, once again, recite the evidence of sudden unexpected death that came into evidence.
That's a little complicated because there's absolutely none of that ties it to Ana Walshe. There's no testimony before this jury that ties sudden unexpected death to Ana Walshe, is there?
Judge, when the court asked me that, my response is the government's case is, using that phrase defense attorneys like to use, it's built on a house of cards suggesting that a homicide occurred without any direct evidence of a homicide. And so another causation of death should be fair game to argue because it's equally consistent. And citing the Eremos and Croft, if you have two equally inconsistent propositions, neither have been proved by reasonable doubt. There is no direct evidence of a homicide. And building on that, we've always said there's no direct evidence that anything that came into evidence, the acts of disposal, the acts of the use of tools, occurred after the death of Ms. Walsh. So why is it that the Commonwealth is allowed to ask the jury to speculate based on their circumstantial evidence, and I shouldn't use the word speculate, reach some conclusion based on nothing more than circumstantial, when there's no direct evidence of a homicide? And we can't, is it
They can met out their burden with that circumstance. The law is clear there. They can met out their burden purely with circumstantial evidence. They can. And their circumstantial evidence with regard to the death, again, are those breadcrumbs and what they're going to argue those breadcrumbs mean, from the searches to the evidence retrieved from the bags and other, the other distinctions in the evidence.
All of which, Judge, as we've always argued and we will continue to argue, came after any death. And so the issue is, what is the manner of death? And we now have evidence that from their own medical examiner, that death can occur suddenly, unexpectedly, without injury, and it's up for the jury to decide if they can. What evidence do they have as to manner of death when the real possibility, if not probability, is sudden unexpected death due to natural causes, as Dr. Atkinson testified to, and it's equally inconsistent with a homicide. All we're saying is they don't have any direct evidence of homicide. So why do they get to argue it based on their circumstantial evidence when their circumstantial evidence really might only speak to conduct post-death, where the death was not a homicide?
But there's evidence in the record before this jury that
I don't want to interrupt folks' thought process, but there was no objection whatsoever to the entire cross-examination of Dr. Atkinson. So all of that testimony is before the jury. It's not like we represented that, we made some representation that we will present evidence later, so we made it.
So you can make an argument based on circumstantial evidence. That's what they're going to do in their case. I presume, I don't know what the Commonwealth's going to argue, I presume that they are going to draw a line between some of the evidence that was retrieved from the bags as being circumstantial evidence of things that happened before the dismemberment.
And I agree, they will.
So, for example, the slipper, the blood in the hair. I presume their argument is going to be that that happened before. That's circumstantial evidence, because once the foot covers are purchased, presumably they were purchased, there's a reasonable inference to be drawn, they were purchased to be used. And that's evidence of something that happened before.
I think that's an argument.
I think that's an argument to be made based on the circumstantial evidence that's presented. But so I'm turning to you and saying, if you want to argue to the jury that there was circumstantial evidence that Ana Walshe died of some natural causes. I'm just asking, what's the circumstantial evidence upon which you base that argument?
That our argument fundamentally would be that all of the evidence that the government suggests was evidence that was created in the context of a homicide. There is no evidence that it was not created after a death. And so, since the jury heard all about the not only just the possibility, but the probability that there is sudden unexpected death, that the jury needs to decide for themselves. Could it have been sudden unexpected death? And all of that evidence that the government is arguing is evidence of a homicide could be only evidence of an attempt to conceal evidence that a person, and using the language and conscience of guilt, a person is acting in a way not out of conscience of guilt, but out of fear or fright or anything of the sort. So why is it that, given the state of this evidence, we can argue our inferences that we believe the jury is allowed to make if they so choose, and if they decide that that evidence of concealment was evidence of a man reacting innocently and not with a guilty conscience, then how did Ana Walshe die? Maybe she died a sudden, unexpected death, and he tried to conceal it out of fear or fright, as is contained in the language of the conscience of guilt. And so the jury gets to decide. And it certainly, the thrust of that argument is that it raises a reasonable doubt. And that's the evidence the jury heard.
Your Honor?
Listen, they may not want, I'm not precluding you from making that argument right now. And in fact, they probably want you to make that argument. I'll hear from the Commonwealth.
Sorry for interrupting, Your Honor. Your Honor, this started out with a motion that the Commonwealth not make any reference in closing to representations by counsel in opening statement. The Commonwealth does not intend to burden shift. The Commonwealth does not intend to refer to matters not in evidence. There certainly was testimony from the medical examiner talking about different ways people can die. The Commonwealth is certainly entitled to comment on that testimony, which is in evidence, but the Commonwealth is not going to comment on the opening statement.
All right.
And that's why I was thinking we might find common ground here.
Sounds like we have.
Pardon?
Sounds like we have.
So as long as we're able to argue that a possible manner of death was sudden unexpected death, I understand that the government's going to stand up and say, nonsense. And we're going to say, homicide, nonsense. Have we found common ground?
I think we have.
I think we're close.
Just keep talking. I don't need to be part of this conversation. I've directed you to the cases why I think they could say something short of commenting on your opening statement. And I've told you what I think they could say. And just be talking to one another.
Thank you, Your Honor.
So that there's no surprises.
There's always surprises.
That's true.
All right. And again, I did not mean to create a whirlwind of activity by my comments. I just think that the idea that they couldn't comment at all about the state of the evidence, I didn't want to leave it there. And maybe the takeaway is I should stop thinking about these things 3 or 4 days before they're going to happen. But you have the cases now. All right? Take a look at the verdict slip. It looks very straightforward to me. I don't think that there's going to be any edits or changes to it. Again, I'll finalize that at the very end, so you'll have plenty of time between now and then to look at it. How long are the parties thinking they're going to need for closing arguments?
No more than 45 minutes.
All right.
That sounds good, Your Honor.
So 45 it is. I won't cut you off in a case like this, of course. I have cut off in other cases when it's a 2-day case and we're on 45, 47, but that isn't this case. And but just I know you'll all have a ton of experience, but 45 minutes is about as much as they can take effectively, in my view. So let's try to keep it to that. Well, we will be getting them fresh in the morning, which is good, as opposed to having, a couple hours of evidence in the bank and they're already tired. That's all I have on my agenda. Anything that you need?
Your Honor, would the parties have an opportunity to see the next draft of the court's instructions?
Yes. So I will be going back and editing as consistent with what we discussed, and I will then create a new draft, and that will go out to you this afternoon.
Thank you.
And if I know that maybe there's some other language you want, I'll consider putting that in the morning. So maybe 8:45 tomorrow, so that when the jury comes in, we don't have a big delay if we need to make any changes. And I think that's it. All right. Thank you. One other thing that I want to say is that you can be seated. I very much appreciate the work that you've done in the case to get the case in and tried efficiently on both sides. You picked what you needed to pick as your positions, and I appreciate the professionalism that you've shown on both sides in working with each other. And as I say, I drop into Norfolk County every once in a while as I drop into other counties. You and I, counsel, and I know that this is pretty much the routine of how the courts in the Commonwealth of Massachusetts operate day to day. There's nothing unusual about this case. The level at which you perform is the level at which I see when I travel county to county. And I appreciate the work that you've done on this case and will continue to do on this case.
Thank you.
Thank you.
All rise.
Matters continue.
All right, that seems to be it. That seems to be it for day 9. Day 9 is over. I've got a redirect for Dustin Duran, so let's go over there and let's watch Dustin Duran. But before we go, the defense rested. Didn't call anybody. Didn't call Brian. Didn't call any of the witnesses that they had on their witness list. They talked about how they're going to do their closings. There's no evidence that Ana died of natural causes. There's no evidence that it was a homicide. So both sides are going to argue that. They have to find common ground as to how they argue it. It's going to be 45 minutes for both sides, and then the judge thanked them for their professionalism. So. All right, you guys, let's go over to Dustin Duran. Thank you for joining us. Really appreciate you spending your morning with us. I have a redirect for Dustin Duran. Sentencing is going on right now. So we will see you over there in a second. Thanks for joining, guys. And thank you to our mods, and thank you to Aaron. Have a good one, guys. Bye.